All right, the recording is now on. Very warm welcome, everyone, to Large Group 5. This is Implied Trusts and Property Disputes. Just a word of caution, you should remember we don't have a large group next week. Next week will essentially be Workshops 5A and then Workshop 5B the week after, so there's going to be that gap there. In terms of the content for what we're looking at this week, you need to, by the end of this session, explain the presumptions that arise when a person makes a voluntary transfer or provides money to buy property in the name of another and how those presumptions can be rebutted. That essentially, that first outcome deals with resulting trusts. That's the first thing that we're looking at. We'll probably spend about 40 minutes looking at that, maybe less, maybe slightly more, depending on the sorts of questions you have. And then the second outcome there, explaining and applying the law on constructive trusts and proprietary estoppel in relation to ownership of a family home. Also, those of you who've just joined, please remember the attendance code is right there. That's what we're looking at. Please, could I ask you to have your student guide with you? It's a good idea to have it open, as I lead this session, and I might just actually have to revert to it myself during some of the discussions that we do have, right? And if you look at the context in your student guide, we give you this example of Jack and Sadie, don't we? Where Jack is the sole owner of property and Sadie wants to claim a share in it, right? And you'll see here that the difficulty with someone like Sadie is that there's been no declaration of trust here by Jack, so she can't really work on that premise. But she can try to argue that there's some, there are circumstances here that justify the imposition of an implied trust, right? Contentious lawyers will deal with property disputes quite frequently, and they will need to know of the situations that give rise to implied trust. So you will not be surprised if somebody came up to you with a problem similar to what Sadie has, and asking you for advice as to what she can do in order to claim an interest in this particular house. So that's the sort of the area you're looking at, right? How can a person claim an interest in a house that's being owned by another? The key difficulty being that there is no declaration of trust in favor of that person, right? Now, within this framework, if you will, there are two sources through which a person can nevertheless claim, two large sources through which a person can claim an interest despite not being mentioned on the face of the transfer deed itself. The first of them we're looking at now are resulting trusts, right? Now, resulting trusts might actually arise when someone transfers money or assets to another for no consideration, right? We refer to that as a voluntary transfer. That's what that voluntariness there signifies, the idea that there's been no consideration paid for that particular transaction or for that particular transfer. And quite often what happens is that a person would have died having transferred something to another for no consideration, and you're left figuring out why they might have done this, what led them to actually transferring the asset here in the name of another person. Um, Another example is where you have someone contributing towards the purchase money of an asset that is bought in the name of another. We'll just get into that shortly and see where that actually takes us. For present purposes, I just want to give you a broad overview of what implied trusts really are. So one version of implied trusts is this slide in front of you, the resulting trust, right? The other version, which we'll look at shortly, towards the second half of this large group, I'm just going to play the slide here, but we're not going to do it yet, is a common intention constructive trust, right? Now that has a different set of facts or a different set of ingredients that you need to look out for in order to see whether or not a person can argue that there is a constructive trust in favor of them. We'll go through those two stages as well, but this is essentially the ambit of what we're looking at, the two implied trusts that I've just talked about. There is a third thing we'll look at, and that is proprietary estoppel. That's going to come up here. And you'll see when we get there that proprietary estoppel is something that could also work in favor of a person trying to claim an interest. In fact, you will see that the common intention constructive trust and a proprietary estoppel claim are typically used interchangeably for the same set of facts. So that's sort of the bulk of what we're looking at. If you go to section 1 of your student guide, we give you a very brief summary of each of these 4 claims. I'm not going to go into the summary yet because I think it's a good idea to first flesh out the actual concepts and then summarize them for us, yeah, so that we avoid overly simplistic conclusions. So with that in mind, if I could start with resulting trust, and if I were to relate this to your student guide, let me just for a moment open up your student guide here so that I can refer to that as we go along. Bear with me one moment while I load that here. So in a minute, what you're going to see on the screen in front of you will be your student guide. Yeah. Bear with me one moment while I do that for us. Here we go. Yeah, this is the student guide, and I want to start with this idea here. The only reason why I sort of like this particular format here is because it's got a pretty neat diagram there that might help you make better sense of it. Let's look at resulting trust and look at them in a bit more detail to see how and when they arise. The first type of resulting trust that you need to be familiar with is the presumed resulting trust, and this is perhaps something that you'll come across most frequently. Why is it presumed? What happens? What is really going on here? Well, the short answer to that question is that in some circumstances, equity simply presumes that a transferor had transferred an asset to another only because they wanted the transferee to hold that asset on trust for them. And we give you an example of when that happens, right? There's actually 2 circumstances in which you might have a presumed resulting trust. One of them is here, voluntary transfers. I'll just begin with that in a minute. The other is on the next page here, purchase money cases. These are the 2 scenarios in which equity will presume a resulting trust. And I think the example that you have there at the very on that particular page of your student guide is a good example to make sense of this. It says that Sam transfers his shares in various public companies to his partner Mary. They're not married. It is a voluntary transfer because Mary does not give consideration. The presumption is that Mary holds the shares on a resulting trust for Sam. Now, try to understand how this works, right? Sam on the left here has made a transfer of assets to Mary. He has not declared a trust over them, right? Typically, let's imagine if I give something, if I transfer legal title to something, and let's say I have a car and I give that car to Timmy, how would you, and then as a run-of-the-mill transaction, interpret that? I give my car to Timmy, I say nothing, and that's it. What would be the logical interpretation to place on this transaction? Anyone? You could use the chat box. Lana says gift. Very good, Lana. That's what we. Natalia says no. All right. I'm interested in what you're disagreeing with there. But the point is, I think Lana is onto something here. That typically, when you transfer something to another, it is logical to assume that this is a gift, right? Without anything more, you'd say that it's a gift. Now, this is where equity has its own quirks because equity is inherently suspicious of gifts. Equity cannot think of why a person would think of a reason why a person would transfer assets to another and expect nothing in return. And it boggles equity so much that equity comes up with a presumption, or has traditionally come up with a presumption. Can I just say, there is a lot of history, contested history, as to why equity presumed what it just did. In fact, the statement I just made there, that equity is suspicious of gifts, is something that a lot of scholars disagree with, right? But they're wrong, I'm right. That's, the point here is that there is a good wealth of literature to support that claim. The idea here is, if you look at this pattern, very good afternoon to you too, Judy. I'll just give you the code here in the chat box if you don't mind. The point here, folks, is that equity had to make some sense of this particular transaction, didn't it? And this is the way that equity came up with, right? That we will presume that the transferor intended to transfer the assets, on a trust for themselves. And this comes from a Latin phrase, resalire. Some people call it saltare. It doesn't really matter because you're not going to be examined on the Latin. But what that word means is it means to jump back. That's what the word in Latin means, and that's where result comes from. The idea being that when Sam transferred the assets to what's her name again, Mary, the equitable interest jumped back to him like that. I've just ruined the diagram, haven't I? But you get the point here, that it goes back to him. That's what is resulting here. Now, you'll see here that if what I've just said is correct, then there is no way on God's green earth that anybody could make a gift without feeling insecure about the fact that this could be challenged in a court. This is why you have to keep in mind the nature of presumptions. You've done presumptions before. I'm sure you've all done contract law. What is the one key feature of a presumption? If I were to ask you that question, are presumptions absolute? Do presumptions hold sway? Excellent point, Natalia. They can be rebutted. I like how you wrote a 3 next to your E there. I'm steal that. But that's absolutely correct. Yeah, presumptions by their very nature are capable of being rebutted. They're no more than a long stop, right? And so all you need to do really is adduce evidence to suggest that, what, this person actually intended to make a gift. And that will suffice. That will allow you to successfully rebut the presumption of resulting trust. So what I'm going to write here just for now, it's going to come up again, so nothing really turns on what I'm about to write, is that presumptions or the presumption of resulting trust is capable of being rebutted by the slightest, well, I'm not going to say slightest, by contrary evidence, let's put it that way. Thanks for that, Natalia, that's very useful, by contrary evidence. That is what a resulting trust, that's what happens if you want to rebut a presumption of resulting trust, right? If you want to actually make a gift, you go through it that way. Now, what we have here in this next section in your student guide is actually something that is quite controversial: voluntary transfers of land. Because the received view today, and I'll give you a disclaimer, I don't agree with the received view. So I've put that out there in case you find a hint of bias in the way I present this. The received view today is that the presumption of resulting trust stands abolished to the extent of land. In other words, the received view today is that if I transferred land to Timmy, there would be no presumption of resulting trust. Timmy can actually assume, as you all naturally did, that this was a gift, right? That's what the received view seems to be. Yes, Timmy.
That because the formalities for transferring land are much more stricter.
It's a very interesting point. And can I just say, it's sort of linked with that. It's sort of linked with what you have in mind. But that strictness of the formalities was sort of the foundation of what I'm about to say. But thanks for raising that's a very important point. And in fact, if we now look at that, the basis for the received view that I refer to is actually section 60, subsection 3 of the Law of Property Act 1925, which, as it states on that slide in front of you, simply says that in a voluntary conveyance, a resulting trust for the grantor shall not be implied merely by reason that the property is not expressed to be conveyed for the use or benefit of the grantee. Now, the question that arose, and that has caused bitter division amongst some of the leading scholars in equity and trust, right? If you don't believe me, read a paper by a guy called John Mee, that's M-E-E, and he details the controversy in a lot of, with a lot of passion. This has divided people. It's divided people because they don't know why this was enacted. Now, let's just take a bit of a step back to remind ourselves of why it was enacted. It was enacted simply because they wanted to save words. We often refer to provisions like this as a word-saving provision, because what used to happen in the past, right? What used to happen in the past is that trusts became so common that if somebody wanted to avoid creating a trust and they were transferring land to another, they would actually have to write in their deed that this is unto and for the absolute use of the benefit of the grantee. This phrase here, for the use or benefit of the grantee, became so common amongst people who wanted to make a gift. Why? Because they knew that if they did not use these magic words, equity might just presume that a resulting trust was intended. In 1925, when Section 60, subsection 3 was enacted, the idea behind the enactment was, you know what, we don't need to have deeds of transfer so long and detailed that they can contain a reference to something of the nature that's highlighted in front of you. In other words, since 1925, it has been possible to transfer land to another without having to use the magic words unto the use and benefit of the grantee. You don't need to say that any longer. That's what the purpose of the provision really was. And nobody disagrees with that. They are all in agreement that this was indeed the purpose. However, there have been obiter suggestions in the two cases in front of you here, Loya and Ali and Khan. In these cases, there is obiter dicta to the effect that the effect of Section 60, subsection 3 is nevertheless to abolish the presumption of resulting trust as far as it applies to land. Timmy. Sorry, Timmy, you had your hand up. You might
Oh,
be on mute.
sorry, that was accidental.
Oh, that's all right. So, the effect of Section 60, subsection 3, according to these two cases, is to abolish the presumption of resulting trust as far as voluntary conveyances of land are concerned. But remember, it applies to other assets. Right? I should also say, and forgive me for shouting this out, that this was an obiter statement. So obiter, right? In both of those cases. Now, I would not have been as skeptical about this position had what is about to follow not actually happened, because I'm going to go to the next page now where we refer to the Supreme Court judgment in Preston Petrodel Resources in 2013. I think you might have touched upon this in contract law, but I'm going to assume you've got no recollection of it. In this case, I'll give you the facts first. Fascinating set of facts. Mr. and Mrs. Brest were divorcing, and Mrs. Brest wanted a financial settlement. Now, Mr. Brest was actually a wealthy oil trader, and he was trying to, as most people do, just trying to reduce the amount he would have to pay his ex-wife. And the way this thing works is, you're supposed to give in family court, you're supposed to give a list of your assets. And what Mr. Brest did was he gave a list of his assets, but he did not include 7 houses, which he had actually transferred to some offshore companies for nominal sums. In effect, they were voluntary transfers, right? So that's what he did. And Mrs. Brest obviously challenged that and said that he should be adding that into his list of assets. There's a whole sort of, we're not interested in the family side of the dispute. We're interested in what the Supreme Court held about the effect of the voluntary transfers. The Supreme Court held that Mr. Prest cannot claim that these houses do not belong to him, because when he transferred the houses to these offshore companies for nothing in return, really, the result of that was that a trust arose in his favor. The companies held the houses on resulting trust for him. And this, Jonathan Sumption was one of the lead. I think he wrote the majority judgment, actually. And he applied the presumption of resulting trust to this scenario, right, to a voluntary conveyance scenario. So let me put that down first. And in this case, the Supreme Court applied the presumption of resulting trust to a voluntary transfer of land. So far, so good, right? And so far, you can understand why I'm skeptical about the received view. However, the court made no reference whatsoever to Section 60, subsection 3 of the Law of Property Act 1925. Now, there are two ways of interpreting that omission. One way of interpreting that failure to refer to Section 60, subsection 3 is to say, well, you know what? They thought it's so obvious that Section 60 does not have the effect of abolishing the presumption of resulting trust that they didn't even need to mention it, right? That's the view that your lecturer subscribes to. The other view is that it's an oversight, that the court did not directly confront that question. And because it did not directly confront that question, you cannot really treat this as authority for the proposition that Section 60 subsection 3 did not have the effect of abolishing the presumption of resulting trust. Where does that leave us? Well, that leaves you with is at least some obiter suggestions to the effect that Section 60 subsection 3 has indeed abolished the presumption of resulting trust to the extent of voluntary transfers of land. Your lecturer begrudgingly accepts that at least the Court of Appeal in Loya and Alian Khan, the High Court in Alian Khan, did confront that question head on, right? So I'd say for your purposes, the received view should be what holds sway, that you should not be applying the presumption of resulting trust to a voluntary conveyance of land. The point is nuanced, the point is still open-ended, but that remains to be perhaps the better view. Now, that brings us to the other scenario where a resulting trust arises. We typically refer to these as purchase money cases, right? And this is a diagram I really love because it's got the tiny house there, to show what we mean. Look at the scenario here. Tess and her daughter Maggie decide to buy a house to let to tenants. Tess contributes £20,000 and Maggie pays the remaining £180,000 of the purchase price. The house is conveyed into Maggie's sole name. Now, this too gives rise to a presumption of resulting trust. The presumption is that Maggie holds the house on a resulting trust for herself and Tess in equity, right? In what proportions? In proportion to their contributions. Essentially, Maggie will be holding this legal title on resulting trust for Tess and herself. I'm horrible at mathematics, and can anyone calculate how much of an interest Tess has in this particular house? Let's see who's fast at maths. If Tess paid £20,000 out of a purchase of, what is it, £200,000? How much of an interest in percentages does Tess have? I'll be honest, I've almost worked it out myself now. Mahad says 11%. That doesn't sound right. It has to be an even number, Mahad. You're trying to trick me there, aren't you? 20%? Is that right? Is it 20? No, no. All right, okay. Let's just say 20 over 200. That's what it is, right? That's what it is. 20 over 200. Mahad says it's 10. Right, great. Okay. I thought I was bad at mathematics, right? But I'm not going to finish that sentence. But clearly, folks, you are in the law for a reason, as Timmy says. 20 over 200, that is 10%, right? That is 10%. So let's just say Tess has a 10% interest under a resulting trust. All right. Can I just say, if you found that calculation a bit challenging, massive spoiler alert, the rules of tracing that come up in units 8 and 9 require a bit of mathematical proficiency. So you might want to brush up on that maths just a bit, right? I have the benefit of having to check my son's homework so I can get some sort of correction. You, I suspect, don't have that luxury, so get some math tutorials on. The point here, folks, is that here too, the reason why equity is intent upon giving Tess an interest is because it does not want to give Maggie a free ride. Maggie did not pay the full purchase price, did she? Maggie paid 180 grand. Tess paid the remaining 20 grand, so Tess should have an interest, right? And that's the extent of her interest here. It's a very important case here, Curley and Parks, that I want you to cite in your workshops as well as in your assessment, really. And by cite, I mean to simply refer to it. Don't write the full citation. What Curley and Parks says is that what we mean by purchase price is things that are paid or payments that are made at the time of the purchase. Let me just write that down for you once. Payments made at the time of the purchase. In other words, what this means is only contributions made towards the initial deposit. Contributions made towards, let me just write this down for you, towards the initial deposit. Let me unpack that for you. I'm going to quickly go to my slides and I'll come back to the student guide. So if you want to lift anything from here, it'll still be there. But I want to remind everyone of the stages involved in purchasing a house, right? A slightly oversimplified way of presenting it, but I think it will help you to get at least some idea of it. This is how a house is typically purchased, right? At stage one, you enter into the contract, and this is typically where the buyer will pay 10% of the purchase price as a deposit. Some banks require a higher deposit. Sometimes the government pushes a policy to let people pay a lower sum as well. And it gives, sorry, let me just quickly take Judy's question. Judy says it gives rise to a purchase money resulting trust, resulting Judy, yes, it gives rise to a purchase money resulting trust. You're right. If you make a contribution to purchase price, that's what the effect of that is. Let's just go back to how you buy a house, right? So there's two stages to it. At stage one, you enter into the contract, you pay the deposit. You're very welcome, Judy, and then you sort of, move on to stage two, which is typically referred to as the completion stage. At the completion stage, the buyer has to pay the remaining 90% of the purchase price. Now, if you're, if you have the money, you can simply pay the full sum. Most people do not have that kind of money. So what they'll do is they'll have to fund some of that remainder, or perhaps even all of it, through a mortgage loan. And the loan will be repayable over a long period, quite often 25 years. Could be longer than that, could be shorter than that. But the buyer will repay the loan in monthly installments over that period, where they'll also be naturally paying interest each month, right? That's how a house purchase would typically work. Now, what Curley and Parks says is that if you want to argue that you made a contribution towards the purchase price, this is the only contribution that will count. In other words, if you paid towards the deposit, the initial deposit, yeah, that will count. Anything paid thereafter, anything paid after the purchase, right, after the stage one contract has been entered into, does not count towards purchase money. That's what Curley and Parks hold, and that's what actually makes resulting trusts quite a narrow kind of vehicle, if you will, when it comes to determining who should own property at the end of a relationship, or at the end of any scenario, really. I'm going to quickly go back to your student guide to make a couple of important points here. Yeah, the points about Curley and Parks being, firstly, that it's just payments made towards the purchase of the property at the time in the initial deposit, right? And the important point here for your purposes is that this excludes a number of things, right? Let me write those down for you. This excludes things in the nature of legal fees, right? Stamp duty, bills, council tax, mortgage repayments. None of that counts for purposes of resulting trusts. Yeah, that's the key point with Curley and Parks. Any outgoings made after the date of the purchase simply do not give rise to a purchase money resulting trust. And that is why in Stack and Dowden, it was held. Sorry, I'm going to take Anjali, you had your hand up. I'm going to assume that was a mistake. All right, never mind. If you do have a question, please feel free. Oh, that's all right, no worries. No problem at all. Maxine, you have your hand up.
So you know how it said this excludes legal fee, stamp duty. Are you talking about the purchase price, or are you talking
Yeah,
about the purchase price? Okay.
yeah.
Thank
So that phrase purchase price, which is the critical phrase as far as the purchase money resulting trust is concerned, would factor in only the initial deposit. It would not cater for things like legal fees, stamp duty, bills, council tax, etc., etc. Yeah, that's the point there. And that's the reason, given this limited nature of things that count. Yeah, you're very welcome. Given the limited nature of the things that count, in Stack and Dowden, the House of Lords actually, the majority of the House of Lords actually subscribed to the view that constructive trusts are more appropriate when you want to determine the rights of cohabitees rather than resulting trusts, right? Majority held that constructive trusts are more appropriate than resulting trust when determining the shares of cohabiting couples. because you'll appreciate that cohabiting couples would not necessarily have each contributed towards the deposit, but they may have paid other amounts that might be significant. None of that gets taken into account when it comes to the resulting trust. Yeah, I'm going to quickly move to the next page before I get into activity 1, which we'll do together. Lascar and Lascar, that's authority from 2008, is simply authority for the limited proposition that resulting trusts are still relevant or continue to be relevant in those scenarios where the property has been purchased as an investment, right? Where property is purchased as an investment. An example of that is actually on the facts of Lascar itself. I can, Maxine, I'll go back to the previous one for a few seconds. On the facts of Lascar, a mother contributed to the purchase of a house in her daughter's name, and the purpose of purchasing the house was to let the house to tenants. Yeah, and well, the mother subsequently had a bit of a falling out with the daughter, and she wanted an interest in the house, and she was given that interest under a resulting trust. Note that they did not need to rely on anything else. It wasn't a family home, so they couldn't argue for a constructive trust either way. But the point being that since it was purchased as an investment, the mother was allowed to recover an interest in the house. And that brings us to the fun of activity 1, right? What I'd like you to do here with activity 1, it's all right, Lana. Once you're done, just let me know. With activity 1, folks, if you could have a read through the facts to decide whether you think each scenario, you're very welcome, whether each scenario is a voluntary transfer or a purchase money case, and then whether a presumption of resulting trust arises. What I'm going to do is I'm going to set this up as a poll if I can, starting with starting with fact pattern A. So if you could just read A, and maybe then answer the question that I'm going to set up as a poll that follows, right? Have a read through it. I'm just setting up the poll here. The question is, what type of resulting trust are we actually looking at here? Purchase money or voluntary transfer? Let's start now. Oh, no, don't do that. Don't do that one. I entered the wrong options there. It should be this one here. Which type of resulting trust? Right, and the first is it a purchase money resulting trust or is it a voluntary transfer? Hopefully, I would not have made a mess of this one. Yeah, there we go. Facts, the first fact pattern. Last month, Miss Mitchell bought various quoted shares in the name of her stockbroker brother, Jake Mitchell. I'll give it a few minutes. Thanks for those of you who have already answered that. We're still waiting for 4 responses. Thanks very much, everyone. Still waiting for Fiona, Maria, Jamil, and Severa. All right, I'll still give it just a few more seconds. Once again, waiting for Severa, Jamil. Thanks for that, Severa. Just waiting for Jamil and Maria. All right, I'm going to show your responses here so that we can make some progress. All of you have correctly identified that as a purchase money case. Yeah, so well done. That is absolutely correct. Let's have a look at the second one now. And if you could answer this one for me. 2 months ago, Mr. Howard transferred his holiday cottage to his grandson, Paul Howard, who registered himself as a sole proprietor. Paul Howard gave nothing in return for the transfer. Now, the question is whether this is a purchase money or a voluntary transfer. Are you able to see the poll or do I need to reset it?
Sorry, you need to reset it because it's not allowing me to click on the voluntary. Oh, sorry.
All right. Can I just say, Judy, I knew that. I just want to make sure everybody was there. But yeah, let me just quickly set this up again. Voluntary. So the question is, which type of resulting trust? Once again, is it a voluntary conveyance or a purchase money? Right, there we go. Hopefully you'll be able to see that. Excuse me. All right, thanks to those of you who've answered. I'm just waiting for 2 more responses now. I'll just give it 5 more seconds, maybe. I'll give it a countdown: 5, 4, 3, 2, and 1. All right, thanks very much, everyone. Now, 7 of you have said it's a voluntary conveyance. 1 of you thought that that was a purchase money. Can I just say that this is actually a voluntary transfer. So those of you who said voluntary transfer, the vast majority of you got that right. This, of course, was a purchase money type resulting trust. Now, since it's a voluntary transfer, let me ask a follow-up question. You can answer this in the chat box or by unmuting yourselves. Does this give rise to a presumption of resulting trust?
No.
Making my rounds as best I can.
All right, Timmy, give reasons for your answer.
Because Paul registered himself as the sole proprietor, so now he has legal title.
Looks bad.
And no
But why?
consideration was made.
But why can it not give rise to a presumption of resulting trust then? Because he transferred, you see, 2 months ago, he transferred his holiday cottage to his grandson, right? Why can Mr. Howard not argue that Paul holds it on resulting trust for him? Yeah, very good, Judy. That's the answer we're looking for, right? Section 60, subsection 3. Thanks for that. The presumption of resulting trust probably does not apply, though, because of section 60, subsection 3, as interpreted by, or as interpreted in Ali and Khan and Loya, right? Those 2 cases. That sort of is the complete answer there. Just to make sure that we, that we don't take too much time with my struggle with the poll, let's look at C, and maybe you can just answer this for me in the chat box. Miss Carroll owns a house in her sole name. 3 years ago, her brother Dean moved in as a lodger and has since paid half the mortgage installments. Dean has also built a conservatory at the rear of the house. Now, let me ask you this. Does this look like a voluntary conveyance or a purchase money contribution? Or does it look like none of the 2?
No.
All right. Why no?
I would say.
Thanks, Maxine. Yeah.
I would say no because of Cotley and Pax. Truly, not at the time, because the payment was not made at the time of purchase.
Excellent. I think that's a very succinct answer. Natalia says mortgage does not constitute. Excellent point, Natalia. Right, and that's exactly where Curley and Parks comes in. Right, Curley and Parks would simply say here that there is no purchase money contribution here. Yeah, let me just write this down. No purchase money contribution here, on the basis that neither the mortgage counts nor the conservatory, or at the rear of the house would matter here. So that sort of settles it for us. Yeah, well done, well spotted on that one. And then finally, Mrs. Snow opens a bank account with £3,000 of her own money in the name of her nephew Jack. Is this a purchase money case or a voluntary transfer case? Think about this one long and hard. This is designed to dazzle. Mrs. Snow opens a bank account with £3,000 of her own money in the name of her nephew, Jack. Purchase money or voluntary transfer? Judy says purchase money. Thanks for that, Judy. I'm going to wait for others to also chime in if they can. Timmy says voluntary transfer. All right, we've got disagreement already. That's fine. How about the rest of us? Lana is sticking with purchase money as well. I'm going to wait for one more response. Maxine agrees with Timmy. Right? I like how you phrase. Very diplomatic, Maxine. And if Timmy gets it wrong, then it's his problem, right? Okay. Can I just say, folks? So let's just first get the answer out here. This is going to be treated as a purchase money case. Let's start with that. Right? It's going to be treated as a purchase money case, and here's why. Mrs. Snow never actually opened a bank account in her own name. That's the point here. Had she actually had this bank account in her own name, and she's now actually trying transfer in the name of Jack, which I don't think is technically possible, then I would have understood why you're saying voluntary transfer. I can also understand why you think it's a voluntary transfer on the basis that it's £3,000 of money being given to Jack. But remember, the asset here is not the money. The asset is actually the bank account that is being opened for the very first time in the name of her nephew, Jack. So that's why it's a presumption of resulting trust arising on the basis of purchase money contributions, right? And that brings us to this little bit here at the bottom of your student guide. Oh, sorry, not here. Here. The presumption of advancement. Now, sometimes what happens is that in a voluntary transfer and in purchase money cases, instead of the presumption of resulting trust, the presumption of advancement applies. And the presumption of advancement is exactly how it's described here. It's the opposite presumption, the idea that the transferor intended to make a gift, right? That's what can apply in some situations. The question is, in what situations does this arise? The answer to that question is that it arises where the transferor is regarded as being under a moral obligation to provide for the transferee. Now, luckily for you, the relationships within which that moral duty exists has been sort of, those relationships have now been sort of spelled out in quite a bit of detail. These are the only four relationships where instead of a presumption of resulting trust, a presumption of advancement applies. So where the transfer is from a father to a child, or by a person in loco parentis to the child, by husband to wife, or by fiance to fiancée, if the marriage does indeed occur, right? Now, father to child, I mean, first of all, can I just say, going through all of this, a person in loco parentis, do you know what that means, anyone? To be in loco parentis to the child? No? To be in loco parentis essentially refers to the idea of you having financial responsibility for a child, right? And this is therefore easier to establish when the child is under the age of 18. And it's a formal sort of thing. I don't know if anybody's ever read a series of unfortunate events by Lemony Snicket, where Count Olaf was in loco parentis to the Baudelaire children. No, nobody. All right, clearly we read different kinds of things, but if you haven't read it, it's a fascinating read. But the point there is essentially that if it's somebody who has responsibility for another, typically for a child, right? What stands out? If I were to say to you that this is the only category of relationships here, right? There's an elephant in the room that we might want to confront. Father to child, husband to wife, fiancé to fiancée. What is no, yeah, exactly, Timmy. But mother to child is not there. Wife to husband is not there. Excellent question, Natalia. Why not? Well, the answer to that is that this presumption is based on Victorian values, and Victorian values were, to put it bluntly, quite sexist. Right? The Victorian values were that the male was expected to support the wife and the family, and that the women were not self-sufficient. And because it is based on those values that today are, clearly have no place in modern society, the presumption simply never developed in that, at that same base. And so the problem is that it still is as it is, right? That there is no presumption between mother and child. There's no presumption between wife and husband. And that's just how it is, right? The case we cite here for that proposition, there's two cases here. The one is Second and Alyssa, and the other is Ree Cameron. Yeah, thanks for that, Judy. Those two cases are interesting because they give you a good idea of what might happen, really. Because Second and Alyssa stands for that proposition, really, that there can be no presumption of presumption of advancement between mother and child. That's what this case stands for. In Ree Cameron, it was suggested, albeit in an obiter dictum, that in modern times, mothers are just under as much of a responsibility to provide financially for their children as fathers are. And so you should be regarding them as being in loco parentis all the time to their children. But again, it's an obiter comment. I don't think it is legally sound to say that mothers are always in loco parentis to their children, just like fathers aren't always in loco parentis to the child. It's just difficult to argue for the presumption of advancement to apply. The key point, therefore, being that you have to be very particular about the precise relationship between the transferor and the transferee. Now, given the inherently sexist nature of the presumption of advancement. Sorry, Maxine, I'll take a question first.
Sorry, what did you say that loco parentis to the child meant again?
If you're in loco parentis to a child, you are essentially financially responsible for that child, right? You are in place of a parent, and that's a loose translation. It's not a very accurate translation, but financial responsibility is what I would say is the accurate representation of what that means. Yeah. No worries. So you have, as I said, the point being that given its sexist nature, Section 199 of the Equality Act, whenever it is brought into force, will have the effect of abolishing the presumption of advancement, right? And there is no commencement date as of today. It's often been doubted whether the presumption will ever be abolished because Section 199 continues to evade enactment in that sense. It's not yet been brought into force. And then finally, a key point here about rebuttal. This little flowchart here, I would, recommend that you keep that with you during your workshops as well, because it's a really helpful flowchart. It tells you how to deal with, resulting trusts in general. The first step being to explain which presumption applies, right? In order to determine this, you need to know what the relationship between the parties is. So I would just put that here, right? Look at relationship between parties. That will tell you whether the presumption of resulting trust applies or the presumption of advancement applies. But that's not all of it, is it? Because once you decide that a presumption does apply, you then have to consider whether there is evidence to rebut the presumption, right? And if there is evidence to rebut the presumption, you have to ask yourselves, is that evidence even admissible? A few minutes we'll spend on that admissibility point shortly. The presumption of advancement is quite weak and it is easily rebutted. Pettit and Pettit is a good authority to stand for that proposition, really, right? The slightest piece of evidence will actually, displace that presumption of advancement. That's the point here. I am not going to say more about this because there are two workshops devoted exclusively, well, not exclusively, but no, more or less, to A, to this flowchart, and B, to other parts of this course. So for present purposes, other parts of this unit, for present purposes, I'll just say to keep that basic structure in mind. Yeah, look at the relationship between the parties, see which presumption applies, and consider whether the presumption can be rebutted. Now, what I'd like you to do is if you could have a go at activity 2, I'm going to give you all of 5 minutes to have a go at this. I want you to read the facts and I want you to answer the 3 questions that follow, right? That will help us make better sense of this. I'll be right here. I'm going to put myself on mute while I try to fix my camera. And so those of you who are following the recording, you'll probably have to fast forward about 5 minutes, but we'll get some feedback at 39 past 4. Right then, that is 39 past 4 now. The good news is that I think I've managed to fix my camera. Yeah, there we go. Let's have a look at the answers to those questions and how you would approach them, having read the facts of McGrath and Wallace now. Was McGrath and Wallace a voluntary transfer or purchase money case? Natalia says voluntary transfer. Timmy says purchase money. Looks like we've got disagreement again. How about the rest of us? Lana says purchase money. All right. So Maxine also says purchase money. Thanks for that, folks. It actually is a purchase money case. And you'll see, let me just get the highlighting off. The reason why it's going to be categorized as a purchase money case is because Mr. McGrath Sr. never actually owned the the property himself and then transferred it to what's his name to his son in that sense. He actually paid the purchase price and it was conveyed in the son's sole name. It would have been a voluntary transfer had he first purchased it in his own name and then transferred it to his son. That would have been a voluntary that would have been a voluntary transfer and a very expensive one at that, dare I add. But nevertheless, the point here being that it's a purchase money scenario for that reason. Which presumption applied and why? Who will answer that? Is it the presumption of resulting trust or the presumption of advancement? Yeah, very good. Nadal, you've spotted it, haven't you? Father to child. We gave you that example in the previous on the previous page. You're absolutely right. Thanks, Natalia. Thanks, Lana. Thanks, Judy, as well. That is absolutely correct. So the presumption of advancement applies for the reasons that Natalia just stated. Right, father to child. Very good. That is absolutely correct. The more important point, of course, being that final question, do you think that this presumption was rebutted by evidence of Mr. McGrath Sr.'s intention? And if so, why? Natalia says yes. All right. On what basis do you think the presumption would have been rebutted? What facts? Natalia says because the presumption would apply if nothing else suggests otherwise. Well, again, the point is that the presumption here, if you think it was rebutted, and can I just say it was rebutted on present facts, what out of the facts that you've just read would have allowed the daughter to rebut the presumption of advancement and thereby establish that a resulting trust was intended? Yeah, very good, Natalia. That's a very important point, isn't it? That he did not intend to make a gift in the first place, right? If you look at this, in fact, there was no reason why he would have made such a substantial gift to his son. Anything else? Anything else that would give you the reason for, or sort of support the idea that he did not intend to make it a gift? If you look at the facts here, folks, anyone, what out of those facts gives you that hint? Joint occupation. Yeah, very good. Thanks to me, the trust. I think that's an important point here, that this declaration of trust was prepared. The fact that it was never accurately, the fact that it was never accurately executed, the fact that it was, it sort of left there due to the solicitor's inadvertence, is besides the point, really, because the key point being that he did in actually going and having that discussion with the solicitor, you can rely on that as evidence of the fact that he intended to not have a gift, as Natalia says, to, not make a gift of it to his son. Yeah. And then finally, I take the point that you say, joint occupation. The only reason why he actually purchased the house in his son's name is actually this bit here. And this was highlighted for you now. The mortgage lender would not have accepted Mr. M Sr. as a borrower because he was unemployed at the time. Therein lies the reason. That's why he bought it in his son's name, not because he wanted to gift it to his son, because he needed a mortgage and he was not a worthy or attractive candidate for a mortgage, right? That's what the key point here is. Final bit on on presumed resulting trust, here at the bottom is the so-called rule in Shepherd and Cartwright, this little rule here, right? This simply tells you about the evidence that the transferor can, or anyone can really rely on. The essence of the rule in Shepherd and Cartwright is that you must rely on evidence of the transferor's intention before or at the time of the transfer, right? You cannot admit evidence of your own acts or your own declarations that occur after the transfer, which help your case, because that would encourage you to win your case or by making up evidence after the event. Right, so this is why Lord Simmons had to say what he did here, right? Before or at the time of the purchase, or so immediately after it as to constitute part of the transaction. Only these are admissible acts and declarations. Subsequent declarations would not be admissible. That's the key point here about rebutting the presumption of resulting trust and the presumption of advancement. More on that in the workshop, by the way, for 5A and 5B. Now, there is one final point here. It's supposed to be at the bottom of your student guide. It's not here in my version, but it should be a reference to automatic resulting trust. Please, can you confirm if it's there in your student guide? Do you have a section? Yeah, Judy. Judy, I think you're on mute. Your hand is up.
Yes, I have it as 2.5, automatic
Okay.
resulting trust.
Great. Good to know that you do. It's not here on this, for some reason, on this version of the student guide. But the point is, we don't, like I said, you're not going to be separately assessed on automatic resulting trust. You just need to know that there is this other type of resulting trust that you've actually grappled with in the initial parts of the course. An automatic resulting trust essentially arises when an express trust fails. Let me write this down for you here, that these arise when express trusts fail. And express trusts can fail for any number of reasons. One example is uncertainty of objects, right? A trust for all tall people will fail because tall people is an uncertain concept. Who gets the money? Well, the money goes back to the settlor because the trust was void to begin with. That's what the basic idea is. So if I were to just put this in the form of an example for you, if I were to transfer money to Lana and say, please hold it on trust for all tall people in this room, and she comes back to me and says, well, you know what, I don't know, that's an uncertain obligation. Now, she cannot keep the money for herself. The trust has failed for lack of objects. She will have to give it back to me. Why? Because that is the law's automatic response, hence the word automatic. The law's automatic response to a scenario where a trust fails. That's it really when it comes to resulting trust or automatic resulting trust. That brings us to the second type of implied trust that we're dealing with. And these are common intention constructive trusts. Can I just say there are many types of constructive trust that are that exist. We are focusing on only one of them. This is the only one actually that's a part of your course. But you have to keep in mind that the constructive trust is a device that courts often use to remedy a situation which otherwise would have resulted in some form of unconscionable behavior going unchecked. And that's the key thread here. Unconscionability is that thread that binds together a common intention constructive trust, as well as proprietary estoppel to a limited extent, as we'll get there. Now, how does one establish a common intention constructive trust? There's two stages to this, and I would like to flag just before we get into this that this is an area students often find challenging. The reason why they find it challenging is because there is a layer of complexity here in the manner in which the interest is established. But if you keep the basics in mind, you really can't go wrong. It's just an idea of reminding yourselves not to get too far down into a rabbit hole and losing sight of the bigger picture. The bigger picture is, at its bare minimum, a common intention constructive trust has two stages. At the first stage, which is on this page here, you have to establish an interest. This is a difficult task. It is by no means easy business. Once you have done this, once you've gone through the difficulty of establishing an interest, you go on to stage 2, which comes up all the way here at page 12, which is to quantify your interest, right? Quantification is, again, not as difficult as one might imagine, but at least it's interest, right? Quantification is again not as difficult as one might imagine, but at least it's definitely not as complex as establishing an interest. Let's look at an example here before we actually move into the thick of it. Now, imagine, as the example in front of you asks you to imagine, Georgina and Mark are an unmarried couple and they buy a house for 300 grand. The house is conveyed in the sole name of Mark. Georgina provided 200 grand of the purchase price. Mark provided the other 100 grand. Now, I want you to note a couple of things about this, really. The house is in the sole name of just one party here, and the other is trying to claim an interest. And you'll be surprised at how common this actually is, right? Many people, just without legal advice, they actually go and do what Georgina and Mark did, i.e. both of them would have contributed towards the purchase price, but the house would only be conveyed into the sole name of one of those partners. We don't have up-to-date data on this, but data from about 20 years ago suggested that out of the 600 cohabitees that were interviewed, 88% said that they had no written agreement about their share in their home, right? Mostly because they have no reason to get any sort of written instrument or declarations, and they say, why involve lawyers? Some people are worried that that might just cause the relationship to lose its charm if you have to discuss the financial matters of it. So just keep in mind that this is a common scenario, number one. Number two, keep in mind that they are unmarried. We do not deal with married couples on this module because they have a different regime that covers them all, entirely. The Matrimonial Causes Act comes into play there. If you're into that kind of thing, the wills and succession module in your summer term might be something you'd be interested in. But for present purposes, remember, when we say cohabiting couples, we refer to two people who are living together as partners, but who are not married or in a civil partnership. Yeah. So the courts do not enjoy the same latitude as they do when they're dealing with dissolved marriages, right? They do not have the same level of discretion here. So back to Georgina and Mark then, when you just read that fact pattern. Since the house is in the sole name of Mark and Georgina paid literally 2/3 of the purchase price, if she wants to succeed under a common intention constructive trust, she first has to establish the fact that she had an interest. To do that, she needs to do two things. Number one, she needs to establish that there was a common intention between her and Mark, that both of them were to have an interest in this house. Secondly, she has to show that she relied or she acted to her detriment in reliance on that common intention that she would have established. And that case there, Lloyds Bank and Rossett from 1991, remains the leading House of Lords case on how these elements are to be established. Now, there are two methods, right, through which a common intention can actually be established. We're focusing for present purposes only on this bit here. Two methods in which you are going to establish a common intention and then detrimental reliance will follow. We remember all these cases from land law. Oh, well, excellent, Natalia. That's a good advantage to have. I wish I remembered things from land law, but I honestly don't. But it's good to know that you do. You've got that good repository then to sort of fall back on. Yeah. Now, if you look at your student guide here, we call this method 1, but please can I say this is just to facilitate your understanding. They're not actually numbered as methods. You wouldn't find a judgment or even a textbook refer to different numerically different methods, right? This is just to facilitate your understanding. But the first way of establishing a common intention is through what we call express common intention. An express common intention, essentially, according to Lord Bridge in Lloyds Bank and Rossett, entails an agreement or an understanding between the parties, usually before, or at least at the time of the purchase, that they would both have an interest in the property. Right? Now, this can sometimes be even at a later date, but it would typically be before. That's sort of the point here, before or at the time of the purchase. So what you're looking for here is an agreement or understanding, but not just any agreement or understanding, an agreement or understanding between the parties that they would each have an interest in the property. Now, key point here is that this is generally going to be an oral agreement. It does not need to be in writing. That's an important point here. Although, of course, if it's an oral agreement, it becomes difficult to prove, but it nevertheless is, for purposes of establishing an interest, sufficient. Examples of when an express common intention was found. You've got one example there in the form of a case called Grant and Edwards. In Grant and Edwards, the legal owner told his girlfriend that he would have put the house in their joint names, but that he was advised not to do this because it might prejudice her divorce. Right? That's the idea here. The girlfriend was going through a divorce. The legal owner gave her that as the reason as to why he did not put the house in their joint names. And it was held that this amounts to an acknowledgement that the girlfriend had an interest in the house, right? The fact that you're giving her a reason as to why it didn't happen seems to suggest that it would have happened, but because of A, B, and C reason, I just thought that it's better not to do it. That's the crux of Grant and Edwards there, and that's an example of an express common intention, right? I should just perhaps write here that this is just for your consumption example of express common intention. That's what Grant and Edwards really is. There are others in your reading that you'll come across when you do have a look at your reading for this week. Be sure to look for other examples as well. It's always good to maintain a repository, some sort of a book or index of cases to help you there. Detriment. Now, detriment has been defined in Rosset, and we give you that precise extract from the judgment to help you sort of navigate it, right? Because what Lord Bridge says in Lloyds Bank and Rosset is that it will be necessary for the partner asserting a claim to a beneficial interest to show that he or she acted to his or her detriment or significantly altered his or her position in reliance on the agreement. This has since become an iconic phrase, significantly altering your position in reliance on an agreement, right? Now, there is no clear evidence on what suffices for there's no clear guidance, I should say, on what suffices for detriment, really. There's a difference of opinion in Grant and Edwards itself between Lord Justice Nurse and Lord Justice Brown-Wilkinson. There is therefore plenty of room for arguing what is or is not detriment. Financial forms of detriment, for example, contributing towards the purchase price of the mortgage, will typically suffice. Maybe even substantial payments of housekeeping expenses would suffice. But short of that, would non-financial things or non-financial detriment suffice? That is unclear. If you just read those two passages from the judge in Grant and Edwards, Lord Justice Nurse said that detrimental reliance refers to, or detriment refers to, conduct on which the claimant could not reasonably have been expected to embark unless she was to have an interest in the house, while Lord Justice Brown-Wilkinson took the view that it is any act done by her to her detriment relating to the joint lives of the parties. And you'll see here that quite often, this is a bit of a tautology, isn't it? When you're defining the word by using it again, it doesn't really further the cause, does it? The key point for your purposes, and this is something I'd encourage you to focus on in your readings as well, is that financial forms of detriment will easily satisfy the requirement of detrimental reliance. It remains possible, though unlikely, for non-financial forms of detriment to also suffice. Right, and so when you're doing your readings, folks, please, if you could look up cases where you find anything that is non-financial suffice as detriment. That's a good case to cite if you are confronted with a scenario where you think you're dealing with something along those lines. So that's method one. If I could just take a step back to remind you, method one is what we call an express common intention, right here. Yeah, express common intention in the sense that the parties clearly had an understanding or an agreement that they were both to get an interest in the property. Method two as we call it, again, not to labor on the numbers, but just to facilitate your understanding, is what we refer to as an inferred common intention. Generally, couples do not discuss how they own the house that they live in, right? So you would not have the sort of express agreement that Lord Bridge referred to. In the majority of cases, in fact, there will be no express common intention. And when that is so, the court has no choice but to look at the parties' conduct and see whether they can infer a common intention that the claimant did or was meant to have an interest, really. The question is, what kind of contributions count for this purpose? Now, there are two views on this, and this is where things get a bit tricky. So I'd encourage you to embrace the trickiness rather than, cop out of it by oversimplifying what the law says. One view is the one that Lord Bridge has, and that's reproduced here in black and white right in front of you. Lord Bridge said that direct contributions to the purchase price, right, whether initially or by payment of mortgage installments, will readily justify the inference necessary to the creation of a constructive trust. But as I read the authorities, it is at least extremely doubtful whether anything less will do. Now, what we refer to here is therefore the idea that only direct contributions count. Right? That's the view in Lloyds Bank and Rossett. Yeah, that only direct contributions. And what do we mean by direct contributions? We mean purchase contributions towards the initial deposit or towards the mortgage repayments. That's it. Nothing else will count. Now, a lot of you will perhaps appreciate that this is a very restrictive view, because if you go back to a different example, right? I mean, imagine if I live in a house which is in my sole name, where I paid the deposit, but my partner bore the entirety of the mortgage loan. Essentially, she would have paid more or less 90% of the purchase price, and yet I would have legal title, right? The point, therefore, is that you have to question whether Lord Bridge was being unduly restrictive in his view as to what kind of contributions count. What sort of conduct can we rely on to infer that the parties had a common intention to share the property? And this is where judgments like Stack and Dowden give you some room for arguing that perhaps Lord Bridge has been a bit too restrictive. In Stack and Dowden, it was at least commented obiter that obiter comments to the effect that Lord Bridge's statement above was too restrictive, right? And that a wider view of contributions or conduct ought to be taken. The best example of that, the best example of a wider approach being taken is actually from this High Court judgment in LaFoe and LaFoe 2001. I'll give you the facts of this, and maybe you can sort of understand why the court did what it did. Mrs. LaFoe paid a substantial amount of household expenses, and that enabled Mr. LaFoe to pay the mortgage installments, right? This was the conduct that Mrs. LaFoe tried to rely on. She tried to say that, look, I didn't directly pay the mortgage installments, right? And nor did I make a contribution towards the initial deposit. So by all means, Lord Bridges' statement would condemn me. But had I not borne the household expenses that I did, the substantial amount of household expenses that I did, Mr. LaFoe would not have been able to pay off the mortgage himself. Therefore, I enabled him to pay the mortgage installments. And therefore, you should treat my bearing of the household expenses as conduct sufficient to infer a common intention that we both intended to have an interest in the home. And this view was accepted by the judge, right? So LaFoe and LaFoe, therefore, is perhaps one of the leading examples of when indirect contributions sufficed. In this case, the indirect contributions were household expenses. Yeah, so LaFoe and LaFoe remains, like I said, one of the leading examples of when indirect contributions sufficed for inferring a common intention. What is the loophole here? The loophole is that LeFaux and LeFaux is a High Court judgment. The comments made in Stack and Dowden were arbiter comments. They were not a part of the ratio. Whereas Lord Bridges' judgment remains an authoritative House of Lords pronouncement of a very volatile area of the law. So you've got sort of, a scenario where you can rely on the current trend, but you can't ignore what Lord Bridge said either. So you have to make sure that you take an informed view here between the kind of contributions that will count for inferring a common intention. Just a final bit here about detriment. When you're dealing with detriment in an inferred common intention scenario, the claimant would have made a substantial financial contribution already, because that same conduct here that Lord Bridge had in mind, contributions to the purchase price, or by way of initial payments or mortgage installments, or even if you look at what Mrs. LeFaux did, bearing household expenses, both of them, or either of them really, are enough to show that the party suffered a financial detriment. So the detriment requirement is easily satisfied when you're dealing with indirect contributions or inferred common intention, if you will. While if you're dealing with express common intention, you know that detriment is just that bit trickier. You need to show that the claimant significantly altered his or her position. That is how the two types of, or two ways in which a common intention constructive trust can be set up. And that's how they vary. What I'm going to do now is I'm going to introduce to you activity 3. I'm going to play a media clip for you in 3 chunks. There's 3 different factual scenarios that you will have. They are narrated by Lisa Stone. And in each case, what I want you to do really is fill out this grid for me, right? 3 set of facts. We're going to pause after each set and try to fill this grid out to see whether or not we think there was a common intention there. If so, what kind of common intention, expressed or inferred, and then finally whether there was detriment. So in a minute, what I'm going to do is I'm going to share my screen. I just noticed my camera still isn't working. Well, nothing can be done about that now. Let me just open up my screen here. Please can I ask you to use the raise hand function to confirm that you can see my screen? All right, okay, finally got a chime there. Everybody, I've only heard 1 chime. Are the rest of you there? Great, okay, thanks for that, folks. So you can see my screen. So I'm going to play this clip now. I'm going to pause when it says pause for review. And if you can't hear the audio for any reason, just let me know immediately. But let's have a listen.
My name's Lisa Stone. I've been living with Julian for 4 years, but the relationship was going nowhere. I've met someone else and I've told Julian it's over. Thing is, Julian bought the house when we first started living together. He scraped a deposit together and got a mortgage for the rest of the purchase price. It was a real struggle, to be honest, but I helped him out, and now I think I should have a share in the house. Whose name was the house in? Julian's. Julian bought the house in his sole name. Why do I think I should have a share? Well, he as good as told me that I was a part owner. When he bought the house, he said that it would have been in both our names, but as I wasn't working, the mortgage lender wouldn't accept me as a borrower, so he had to put it in his name alone. What contributions did I make? Well, when I got a job, I used to pay for things like holidays, furniture, and going out.
All right, then, let me just bring that grid back up. You've had to read through that first set of facts from Lisa Stone's difficulty. Let's start with that there then. On the basis of these facts, what kind of common intention are we looking at? Was there an express common intention or an inferred common intention between the parties? Who'd like to take that for us?
Express.
Yeah, thanks, Maxine. Was that you? Couldn't see. Was that you, Maxine? Yeah, I think it was you. Very good. Yeah, thanks, Natalia. Thanks, Maxine. That's absolutely correct. It was indeed an express common intention, right? For the reason that Julian actually said he would have. He said something similar to what the partner in Grant and Edwards had said, I would have given you, I would have put the house in your name, but mortgage lender will not accept you. So good, it's an express common intention. Was there detriment? Did Lisa suffer any detriment as a result? Remember, did she significantly alter her position? What expenses did she pay? Natalia, I take the point, but what expenses did she pay? Not significant. Yeah, I agree. I think she's done very little here, actually. Furniture, holidays, etc. Yeah, thanks, Maxine. Thanks for that, Natalia. Yeah, that's probably not going to suffice, is it? Paying for holidays, furniture, going out, those are not things that will count for purposes of detriment, because these are things that you also enjoy. And so there's nothing there really to base detriment on. So yeah, I would say on that basis that there is probably not present on these facts, right? Because holidays, furniture, etc. do not count. Right, I'm going to put that up here. All right, I'm going to go back to the media clip to go to the second variant of the same clip. Oops, bear with me one moment, folks. And once again, can I please say that if once you are able to, yeah, if you could please again use the raise hand function to confirm that you can see my screen, that'd be great. All right, okay, looks like that's working. Thanks, Lana. I'm going to play this again, and we're going to pause at the next prompt.
Why do I think I should have a share? Well, I paid half the monthly mortgage payments. Julian would never have managed to pay them had it not been for my contribution. Did he promise me a share? Well, not in so many words. It was just an understanding. But I'd hardly have paid half the mortgage if I thought I wasn't getting a share in the house, would I?
All right, let's help Lisa out then. What do we think here? Again, same question first. Is this an example of an express common intention or an inferred common intention? Who would like to take that? Maxime says inferred. Natalia says inferred. Yeah. Judy says inferred. Yeah, thanks for that, folks. I think that I agree with you there. There's nothing, as she said there, if he didn't say anything in so many words, then it can't be an express common intention, right? It has to be inferred. In this case, the conduct on the basis of which you're going to be inferring it is what? What did she do? Half the share, half the mortgage. Very good. Thanks, Demi. Thanks, Judy. Right. So this would be the point here being, I take the point here that Natalia, you're citing LeFaux and LeFaux. I don't think you need to cite LeFaux here, do you? Because she is actually paying half the mortgage. She's not enabling Julian to pay the mortgage. The fact that she's making direct contributions to the mortgage is substantial enough to give her that. Yeah. Direct contributions to the mortgage. So this is a direct contribution, inferred common intention. What's the detriment? Given that it's an inferred common intention, will detriment be established? Natalia says, yes, give reasons for your answer. Natalia says, financial. Yeah, good. Thanks, Judy. Yeah, financial form. Thanks for that, Natalia. You're right. It's the same money, right? Money spent on the mortgage payments. Yeah, the same conduct on which you're inferring a common intention will suffice to establish detriment. Very good. Nearly there. Let's look at the final variant of the facts now, if you will, please. I'm going to once again share my screen. And once more, if I could please ask you to use the raise hand function to confirm that you can see my screen. All right, excellent. Looks like it's working now. I'm going to play the clip and then we'll let it run through to the end.
No, Julian didn't say anything definite about me having a share, and I didn't pay any of the deposit or mortgage. But we had a tacit arrangement. I paid all the household expenses, so I got the shopping and paid the gas and electricity bills. This left Julian free to pay the mortgage payments. If I hadn't paid the bills, Julian couldn't have afforded the mortgage. Once it had been taken from his account, Julian had almost nothing left to live on, so he did depend on my contribution.
All right then, let's go back to that same question then and help Lisa out here, not Julian. Know thy client. What do we think here? Is this an express or an inferred? Well, thanks, Timmy. Timmy has beaten everyone to it this time. It is indeed an inferred common intention. Thanks, Judy. Where were we? Oops, yeah, we were here, weren't we? Bear with me one moment. Am I at the wrong page? No, there we go. All right, so it's an inferred common intention. Let me just put that here. And again, you can't just stop there. What are you inferring it on? Is there a direct contribution here or indirect contribution? Judy says financial contributions. Timmy says paid all household expenses, gas, electricity, etc. That is correct. How would I classify these? Very good, Natalia. I'd classify these as indirect contributions. So this is the suspect area in the sense that it does not sit well with Lord Bridge. He would probably not have approved of this. But what case can we rely on to argue that these kinds of contributions, the one that Timmy has just stated, in fact, let me just steal that from the chat box and put it here. What authority can you rely on to argue that this should suffice for an inferred common intention? Yeah, thanks, Natalia. LaFoe and LaFoe is a good authority to cite here, as well as Stack and Dowden, right, to the extent that it gave credence to that idea that you should take wider things into account. So yeah, very good. On the same basis then, is there detriment? Yeah. How can you establish detriment, Timmy? Financial? Yeah, good. Right, detriment, that requirement is probably satisfied. The same conduct, right, i.e. incurring financial detriment through what did you do? Payment of. Yes, Maxine, I'll take your question.
Quick question, sorry. When you say detriment, do you mean like, was there any losses, or do you mean like, was there something that was detrimental to their to why they should be able to get something from it? Because I understand like what you would put in the detriment bit, but what exactly does it mean, if that makes sense?
No, it does. It's a good question. So the detriment here would refer to the detriment suffered by the person. And I said to you that it has to typically be financial. There are instances where non-financial kinds of detriment might also suffice, but it's detriment to the person, right? Some sort of loss that the person might have had to suffer.
Okay.
That would be what counts. Yeah, does that make sense?
Yeah, that does. Thank you.
All right, great, no worries. And so, yeah, I think you've all got that spot on. Well done on getting activity 3 right. A lot of people do find that a bit challenging. So if you've made sense of it so far, I think you'll be fine. Just to summarize this for you, a claimant will get an equitable interest under a constructive trust if, number 1, they establish that there was a common intention. Now, that common intention can be expressed or inferred, right? The idea of how a court is going to infer a common intention is still a developing area of the law, so let's keep that in mind. Number 2, the claimant must establish detriment. Detriment is easy to establish in inferred common intention cases because there the person would have suffered some financial detriment, and that's easily referred to as satisfying that requirement. In a express common intention type scenario, you'll need to show that there was some material change in the or alteration in their circumstances, right? Now that will allow you to establish an interest. The next thing you have to do is quantify the interest, and that is where Stack and Dowden comes in, which gives you the approach towards quantification. Now, this is a very helpful approach. The first thing you do is you try to, according to Stack and Dowden, you try to give effect to the share which the parties might have agreed upon themselves. Now, if the parties did discuss that we both own the house equally, or maybe you'll have 70%, I'll have 30%, that will prevail. In most cases, there will be no such express agreement, although there could be, but in most cases there isn't. And that's where you then have to survey the whole course of dealings between the parties That phrase there is critical, and that will invite you to consider several factors, including these listed here. I'm not going to read them out for you because there's a good list of factors here that you need to look at. What a court will do is it will look at those factors to arrive at a number. That number will essentially be the percentage of share or interest that the claimant is going to be awarded, right? In the assessment, you don't have to give a full number, an accurate number. You just have to indicate what, on your reading of those factors, a person is likely to get: more than 50%, less than 50%, or significantly less than 50%. More on that in the workshop. Again, we're going to have you apply those factors actually to a scenario. Just keep in mind that when they're quantifying the claimant's interest, the key point here is that they do take into account non-financial factors as well. At the first stage, at the stage of establishing the interest, everything is financial. Monetary things are all that matter. Here, you have non-financial things being factored in. For example, looking at whether they had children, right? Looking at the nature of their relationship, looking at the purpose for which the house was acquired, advice or discussions at the time of the purchase. These are all non-financial in nature, and they will be factored in at the quantification stage only. And so in many ways, you'll see it's the common intention constructive trust is front-loaded or top-heavy. To get into it is a difficult thing, but once you're in, you do get a range of factors taken into account to have it quantified. Finally, that authority there, Jones and Gernot's, the Supreme Court judgment, where the Supreme Court essentially held that the parties express or inferred intentions regarding the size of their shares can actually change over time. Intentions of parties read their shares, right, can change or evolve over time. They're not static by any sense. And so what the court will have to do is the court will survey the whole course of dealing between the parties, the whole course of dealings. In other words, what you can't do when you're quantifying somebody's interest is just cherry pick one point in their relationship and say, well, this is where we're going to quantify your share. No, you're going to look at the entire course of the relationship and see how the relationship changed, evolved, or whether there was any kind of, any kind of discussion that might lead you to arrive at some sort of a concrete share. But that thing is going to be done, really, right? That's something that you have to keep in mind when quantifying a share. More on that, as I said, in the workshop, when we'll have you actually apply this head on to a scenario. And that brings us to the final thing you have to do today, which is proprietary estoppel, right? And a proprietary estoppel will requires us to first have a look at a media clip by about Jacob Rawlings. Now I'm going to play the media clips for you, right? I'm going to play part 1 first, and then I'm going to pause, and then I'm going to play part 2. And at the end of them, I'm going to ask you, on each of those sort of pauses, whether you think equity should intervene. In other words, whether you think Mr. Rawlings behaved unconscionably, and whether you think, therefore, equity should intervene. Can I say, this is my second most favorite video on this course. My favorite comes up in Unit 8. You can't beat that one, but you'll have to stick around for Unit 8 to get there. I'm just going to play play this media clip for you. Once again, I'm going to ask you to please use the raise hand function to confirm that you can see my screen before I proceed. All right, great. Looks like that's working. So I'm going to play this up to the first prompt for pausing. Let's have a look.
Jacob Rawlings was a wealthy farmer. He owned 200 acres of prime farmland in Shropshire. He kept cattle, but made most of his money selling potatoes to a leading crisp manufacturer. When Jacob Rawlings died last month, his estate, including the farm, was valued at £6 million. In his will, Jacob Rawlings left one half of his property to the RSPCA, a registered charity, and the other half to his 2 youngest children, Megan and Louise, equally. In fact, Mr. Rawlings had one other child, Peter. Peter is upset that he has been left out of his father's will. Do you think Jacob Rawlins' conduct was unconscionable and that Peter should receive a remedy in equity?
All right, what do we think about that? I'm not going to bring up the screen again yet, but what do you think? Do you think that Mr. Rawlings, should equity intervene? Is Peter being given a raw deal here? He's been left out of the will. Natalia says would be good. What would be good? What should you do? Do you think there's a good ground here for equity to intervene? It would be good to intervene. All right, okay, fair enough. Does anybody take a different view? Think about it. Is it open for a guy like Jacob Rawlings to leave everything to charity? There's a reason he was left out, then equity should intervene. Lana, let's explore that further. Let's imagine there's no reason. Let's just imagine he dislikes Peter, right? It's within the realm of possibilities. He just doesn't like Peter. Can he lawfully leave Peter out of his will? Yeah, that answer is correct. Thanks, Lana. Thanks, Natalia. The law in England and Wales, thanks, Maxine. The law here is, there's this principle of testamentary freedom. The idea being that you are free to dispose of your assets as you please. So if I write a will, I can leave my property to anyone that I want. Now, there is a burning controversy over a piece of legislation. I agree, Timmy, it might be unconscionable in the sense that maybe, you've got that moral obligation to provide for your child, but from a property law perspective, there's this principle, like I said, testamentary freedom and freedom of trust, the idea that you can do whatever you want to do with your property. And that's why there's nothing that can compel people to leave property to, someone who's related to them. And that's just how the law is here, really. Judy says establishing. Oh yeah, Judy, good point. Maybe he could argue for a common intention constructive trust. An estoppel, as you have in mind. We'll get to that. Maybe an estoppel could help him out, but not here. If he has been left out of his will and there's no reason, no unconscionability here, it's not going to really work. The equity will not help him out. I was just making the very small point about the fact that there is one statute, the Provision of Family Dependence Act, which is not a part of your course, where now you do have the possibility for people who can argue that they were owed some kind of, legacy under a will, that they ought to have been left a legacy in a will, but they were not. They can actually argue that we were dependents and therefore there should be some provision made for us. Again, that excitement comes up in wills and succession, not here. I'm just flagging it because I don't want to make an overbroad statement. The general rule holds true. In English law, there is no compulsion to leave property to anyone. You are free to dispose of property the way you want to dispose of it. Let's look at the second variant of this now.
Peter Rawlins is 46. He left school at the age of 16. Since then, he's lived at home with his father and worked on the farm. His work included looking after the livestock, getting up at the crack of dawn to do the milking, mending fences and farm buildings, harvesting potatoes, taking cattle to and from market, and doing the paperwork, because it was never his father's strong point. Peter always understood that he'd inherit the farm when Mr. Rawlins Sr., his father, died. His father had made a will to that effect many years ago. So Peter was shocked to discover that it had been superseded by a new will, leaving everything to charity and his sisters. Peter was not paid for his hard work, even though he worked 18 hours a day, 7 days a week. His father told him that he should be grateful because he was not paying rent and the farm would be his one day anyway. Peter had no social life and lived on the small sum his mother had left him. In 2001, Peter met a lady through a dating agency. She lived in Liverpool. Peter was considering setting up home with her, but his father dissuaded him because it would mean that Peter would move to Liverpool. At that time, his father seemed keen to form a business partnership with Peter and even went to visit a solicitor. But the plans didn't progress because Mr. Rawlins Sr. didn't want to pay all the legal fees. He told Peter that when something happened to him, The farm would be Peter's anyway, so what was the point of feathering the solicitor's nest? Do you think Mr. Rawlins Sr.'s conduct was unconscionable, and that Peter should receive a remedy against the estate in equity?
All right. Timmy says yes, 100%. Oh, I'm not allowed to say that. Natalia says yes because he did works. Absolutely. Yeah, very good. I agree. I mean, clearly, we're all feeling very passionately about this one, aren't we? Less on the fence. Out for his hard work. Yeah, absolutely, Judy. Right. I mean, there's plenty to unpack here when you're trying to think about what Rawlings Senior has done here. But you'll see here, I think there's a number of things when you actually break it down. There's a number of things that have happened here. Firstly, you'll see. Again, points you've all made here. Mr. Rawlings actually encouraged Peter to believe that he would inherit the farm. Then to go back on that is just cruel, isn't it? And then he let Peter work for for hours, as Natalia says, he worked there, right? Sorry, as Judy said, out for his hard work. Yeah, Natalia said that too. Judy says deceptive act. Yeah, that is deceptive. I'll give you that. How about the girlfriend? Right? I was so excited about the girlfriend, and then he had to abandon those plans as well. In all, I think that's a very difficult life to have had to have lived for Peter. But you'll see here, I think that I don't have to make the point here. I think you all are feeling passionately enough about this that it was substantial detriment here that Peter suffered over a period of 30 years, and Mr. Rawlings should not be allowed to go back on the assurances that he gave. And this is where equity does, in fact, help out. If you're looking for a case with slightly similar facts, but less dramatic, you can look at a case called Gillett and Holt, and the other one is Thorner and Major. I'm just going to write these down here just for your consumption. They will come up in your readings, so make sure you read them in full. Gillett and Holt is perhaps one of the most important cases on estoppel because of how successful the remedy there was. So, and this is where proprietary estoppel comes in. How do we stop Mr. Rawlings from doing what he did to poor Peter, right? And that's where proprietary estoppel comes in. It's an equitable cause of action that prevents the legal owner of property, in this case, Mr. Jacob Rawlings, from denying that another person, in this case, Peter, has or might have a remedy in the property. Now, you might think that this is similar to promissory estoppel, but can I just say, as an equity fanatic, proprietary estoppel is by far the better doctrine, right? You can't convince me otherwise. I've already made up my mind. The point is, it's a good way to understand how equity does what it does here. Once again, it's a point Judy made a few minutes ago. There's two stages here. First, you have to establish an equity, yeah, and then you have to satisfy that equity. And the way to establish an equity essentially requires you to do two things as they're listed here. I could actually break it down into three. The first that is, sort of reproduced for you here is that A must have given an assurance to B that B has or will acquire an interest in A's property. Now that's an important thing, an assurance. That assurance can be active, it can also be passive. We'll talk about that in a while, especially in your workshop. But that's the basis for it. Just like in promissory estoppel, there has to be some, I think there has to be some promise or some representation. Here it's an assurance. The other thing that must happen for an equity to be established is that B must have reasonably relied on that assurance to his or her detriment, right? And why does equity intervene in this case? Because if these things happen, usually it would be unconscionable for A, the transfer, the assurer, if you will, to go back on his words. Now, we've got a couple of cases. Again, they're already cited here at the bottom, Gillett and Hold, and then the other one here is Pascoe and Turner. I just want to talk about both of them very briefly, although, as I keep saying, they're a part of your reading, so do make sure you engage with them a bit more in depth when you do your reading. In Gillett and Hold, Holt was a farmer, fairly wealthy, and he had no family. Gillett worked for him for more than 40 years, ever since he left school. And he was repeatedly told by Holt that he would inherit the farm. So you see, Gillett worked for low wages. He turned down other job opportunities because he knew he was going to inherit the farm. And then ultimately, Holt did something quite dreadful. He cut Gillett out of his will. Now, what was held here, Gillett obviously went for a claim under proprietary estoppel, and it was held by the court that one of Holt's farms should be conveyed to Gillett, along with a lump sum of £100,000. Why? Because again, there was active assurance given to Gillett that he would inherit the farm. Gillett relied on that, and it was reasonable to rely on that because he's, of what he's doing here. He's working on the farm for low wages. He's not doing anything else, and to now go back on that would simply be unconscionable. That's why Gillett was given a remedy. Similarly, in a case called Pascoe and Turner, Pascoe had bought a house in his sole name, and he lived there with Mrs. Turner. He then left Mrs. Turner for another woman, and as he was leaving, the evidence suggests that he said, "This house is yours and everything in it." That's what the transcript says, at least in the judgment, and Pascoe doesn't deny it. Mrs. Turner spent a quarter of her savings on the house after that was said to her. And then what happened was that Pascoe tried to actually recover the property, right? And so, he said, "I have legal title, so I want the property back." Ultimately, Mrs. Turner had to obviously apply for a remedy under proprietary estoppel, and she succeeded in having a remedy to the effect that the court ordered, that the fee simple be conveyed to her. Now, once again, if you break down the fact pattern here, there was an assurance given, right? This house is yours and everything in it is a pretty clear assurance. And Mrs. Turner relied on that. She spent her savings on the house. And then Pascoe tried to recover it. It's unconscionable now for Pascoe to go back on his words. The point I was making, of course, is that it doesn't have to be an active assurance like you have in Pascoe as well as in Gillett and Holt. Note that the assurance can be active or passive, right? A passive assurance would be one where you don't actually say that you'll get an interest in the house, but you have led the claimant on to believe that they will get a share in the property, and you simply stand by letting them continue to act in that mistaken belief. That's how the assurance just needs to be broken down here. The other key point I want to focus on from within Gillett and Holt is to do with detriment, right? Detriment, according to Gillett and Holt, need not be financial. That is a crucial difference between proprietary estoppel and common intention constructive trusts. In common intention constructive trusts, I said to you that you would typically need financial detriment. In proprietary estoppel, it does not have to be financial. It can be anything that causes you to lose something, really. And more on that again in the workshop when you get into the actual tasks where you have to apply this. But that's the point. In many cases, what happens is that instead of actually suffering financial detriment, you've actually had to forego something. And that foregoing can often be considered to be enough for a remedy or for detriment in that sense. How do you satisfy the equity, the remedy? This is where estoppel gets a bit tricky. In many cases, what happens is that the claimant would have derived a benefit from the arrangement. For example, in Pascoe, Mrs. Turner got rent-free accommodation, didn't she, for a number of years? Now, what happens is that in these cases, courts will have to weigh the benefits that the claimant has received against the detriment that they have suffered and decide what kind of remedy to give them. And this is where courts have a considerable amount of discretion. Right. In Jennings and Rice, which is the first case that is listed here in your student guide from 2003, the idea was that there must be proportionality. This is the guiding feature. Proportionality is what you want to seek between the expectation and the detriment. So it has to be proportionate. For example, if my partner says to me that I will leave you the house after I'm gone, it's yours. And in reliance on that assurance, I spend £10 to, I don't know, maybe change a light bulb or something. clearly the detriment I've suffered is not in any way proportionate with the expectation that I should get the entire house. Yeah, that's not going to work. So there has to be some level of proportionality. That's where Jennings and Rice comes in. The other thing there, the other authority there on the slide in front of you is guest and guest. Now, this is a Supreme Court judgment, a very divided Supreme Court, if I may add, 3-2. Where the Supreme Court laid down the modern approach towards remedies in estoppel. The court held that once you've established the equity, right, now, according to Guest and Guest, the starting point is to actually try and fulfill the promise, right? In other words, whatever was assured to you, try to have that fulfilled. Only if that is not possible, right, because of any number of reasons such as practicality or justice between the parties, a proportionate remedy may be awarded. Yeah, the key point here, folks, is that it is very much possible for someone to succeed in establishing an equity, right, and to that extent being able to get into that realm and yet be given a very useless kind of remedy, maybe just financial compensation, or maybe just the right to reside in the land for a number of years or something, and that's the point here, because in Guest and Guest, the majority said that we should try to enforce an expectation. But if that's not possible, then we'll go for a lesser remedy, as it were. And this now is the modern approach, as it were, really, right? I would encourage you to read this as well as the High Court judgment in Spencer and Spencer from 2023. Right, this is going to be a part of your reading, and I'm flagging it now because it will help you in the workshop in particular, right? How to approach the question of remedies. Now, where does that leave us? What we've looked at today, I'm going to quickly go back to my slides, if you don't mind. What we've looked at today is implied trusts primarily, right? And we've looked at how equity can actually intervene to go into these kinds of areas, right, where there's no express trust, how equity can help. We've talked about the presumptions of resulting trust, looking at when voluntary transfers or purchase money contributions are made, and then we've looked at how constructive trusts and proprietary estoppel could also help, in letting that, in having that, giving a remedy to a claimant in that kind of scenario. That is it from my end, and I'm going to stop the recording now. I will